Language discrimination in the workplace is a complex and often misunderstood issue. Is it really illegal to not hire someone because they don't speak English? The answer isn't always straightforward. Language discrimination falls under national origin discrimination and is generally unlawful. It occurs when an individual is treated unfairly due to their speech, including accent, vocabulary, and syntax. This type of discrimination can impact hiring, promotions, workplace policies, and access to services. Federal law, specifically Title VII of the Civil Rights Act of 1964, protects individuals from discrimination based on national origin and race. The Equal Employment Opportunity Commission, or EEOC, is responsible for enforcing this law. So when can employers require English proficiency? The key is business necessity. Employers cannot require English fluency unless it is essential for the job. For example, a customer service representative dealing primarily with English-speaking customers may need to be fluent in English. However, if language skills are not crucial for job performance, such requirements may be unlawful. English-only policies in the workplace are a particularly contentious issue. These policies must be justified by business necessity and not used as a means of discrimination. If implemented, employers must notify employees when English must be spoken and outline penalties for breaking the policy. Some states, like California, have additional restrictions on English-only rules. Accent discrimination is another important aspect to consider. Employers cannot show preference for certain accents over others, as this could be considered discrimination based on national origin. However, if a person's accent significantly hinders their ability to communicate clearly in a role where clear communication is essential, an employer may have grounds to make hiring decisions based on this factor. What legal protections exist for those facing language discrimination? Employees who have suffered discrimination can seek remedies including back pay, job offers, and reinstatement. The EEOC handles complaints for companies with more than 15 employees, while the Department of Justice's Office of Special Counsel handles cases for smaller companies. If you believe you've experienced language discrimination, it's crucial to act quickly. For most cases, you should file a charge with the appropriate agency within 180 to 300 days of the Discriminatory Act, depending on your location and the size of the company. In conclusion, while it can be illegal to not hire someone solely because they don't speak English, the specifics depend on the job requirements and business necessity. Employers must carefully justify any language requirements or policies to avoid discriminatory practices. Understanding these laws and protections is crucial for both employers and employees in our diverse, multilingual workforce.